Hey guys, this week is a lot different than my usual YouTube presentation. Today we are in Savannah, Georgia, because I regularly go out in the field and I have to fight free speech battles. And today brings me here to the Deep South on behalf of Accuracy in Media. And they've given me full permission to talk about this today, and I'm not here to sell you on their case, but to educate you about what a free speech defamation defense case looks like. Let's jump into it. So, Accuracy in Media is an organization that's gone out for the past couple of years and has been at the forefront of covering allegations of anti-Semitism on Americans' campuses, particularly in student debates, student protests about Israel and Palestine. Who's right, who's wrong, who's the hero, who's the victim. And in doing so, Accuracy in Media tends to use leading edge technologies, digital billboards as they go about, and they take up pictures of students, of staff members who they think are anti-Semitic, and they will drive those mobile billboards around. They'll create websites in the names of students, all in furtherance of their free speech rights, to be able to point out what they think are anti-Semitic developments among the student populace at Harvard or Columbia or Northwestern. This case was at Columbia University, but it involved a student who was raised and had presumably his domicile in Savannah, so that's why we're here. We were sued in Savannah. Now, what's interesting about this is about just over half of American states have what are called anti-SLAPP laws. What's anti-SLAPP? Well, anti-SLAPP is a recognition that sometimes people use the law not because they have justice on their mind, but they just want to shut you up and they want to create a financial burden and put you out of business. So anti-SLAPP laws are a way to expeditedly, quickly examine the merits of a free speech case. And if it appears to be frivolous, if it appears to be unsupported, shut it down rather quickly. So why is that important? Don't we have First Amendment case law? Don't we do all that? So anti-SLAPP laws are really important because, if you've heard about lawyers, we're expensive and fees mount up very quickly. So without an anti-SLAPP law provision in place, we have to go through either motion to dismiss or summary judgment proceedings, which involves a hefty amount of discovery. That's going through things like, what did you send over your text messages? And it's not just enough to say, here they are, but to go through with e-discovery and to pull out each and every one. Phone call logs, emails, interviewing witnesses, depositions. This becomes a very expensive ordeal, oftentimes in the hundreds of thousands of dollars for even a basic defamation defense case. So if you're able to be sued in a state that has anti-SLAPP, it's an incredible maneuver, it's an incredible tool that we as litigators use to help our clients be able to shut these down more quickly and much less expensively. In fact, in many states you can get your own attorney's fees paid for by the other side if they brought a frivolous claim. So what does this suit involve? Well, as I mentioned, Adam Gillette goes across the country and he looks at students who have been engaged in speech that aligns themselves with groups like Columbia University Apartheid Divest, which seems to have anti-Semitic connections, calling for death to Zionists, or at least members who do. And in this particular case, a student was featured on a billboard and on a website, and there was one mistake made on the website, whether she was a person holding a sign or not. It's clear that she was part of a protest, it's clear that she was arrested, that she was connected to the group, but there were mistakes made that were rather quickly corrected about who was holding that sign. And the lawsuit here involves that minutia and working through, does that simple mistake rise to the level of what we call actual malice in defamation? Actual malice was developed in New York Times v. Sullivan because when we have public controversies involving public figures, we want more speech, more criticism, more commentary. So we set a really high bar in defamation law to be able to say that you have an actionable claim. And that means that you entertain serious doubts about the truthfulness of your publication. As I argued to the court, that requires 3 red flags, and we worked through some of the big cases, Hart Hank, Saint Amant, and in even a Georgia Supreme Court case, Cottrell v. Smith. I won't bore you with their details right now. but all of them hold that there have to be serious indicators of the probable falsity of a story, many of them hitting you face on, before we're going to impose liability. Every publisher, every newsman makes simple, honest mistakes from time to time, especially when they correct them. We don't impose liability. That would kill the First Amendment, it would chill expression, and it would stop news gathering. So I'm proud of my client for taking this task on. I'm part Jewish myself. I worry about the rise of anti-Semitism in American campuses. I think he's doing a fantastic job out there in the field documenting this, and I'm here to protect him and other rabble-rousers and investigators who want to dig into this and use their First Amendment rights to be able to expose injustices.